Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican police are
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday. How was your weekend, everybody? Mine was wonderful. That's what his mind says. I love this intro. I like it too. I'm a bit partial. I'm maybe a little biased. All right. Welcome. Kim R, congratulations, first in chat this morning. For the first 5 minutes, it was just Kim. She just talked to herself in chat for ages. Kim, congratulations being first in chat. I was a little earlier. I was a little early on the whole posting of the video, so I guess people were a little unprepared, but not you. You were here promptly and all by yourself. Congratulations. You need to take care of everything internet related worldwide because we're gifting you the internet as a punishment for your promptness. So Kim, you're in good company. Red says I talk to myself too all day long. We all do it. I just assume there are people out there. I might just be talking to myself as well. Oh man, happy Monday. I'm super excited. I get my new bike today, and I'm not sure who's more excited, me or my kids, who all think that it will be their bike. So they're like, "How big do you need to be to ride it?" Yeah. Anyway, it's going to come probably just before the end of the show, is my guess. So, Michelle Johnson, hello, good morning, welcome. I don't often share little hate mail I get, but I got a message on a video with somebody really upset with me, and they told me that they've been following court cases with me for the last 5 years, and just unsubscribed because they disagree with my opinion on this case. And I'm like, bummer, it's sad to see you go, but I'm really curious what cases I was doing 2.5 years before I started following cases. I'd love to know what we covered together, because I missed all that. 5 years. Talk about OG. Ollie says, don't show what I sent you. No, I didn't see what you sent me. What did you send me? Oh, not that. No. Holly, I don't think you sent me any hate mail. You sent me something from Amazon, but that was different. Anyway, I'm like, 5 years ago, the channel did exist as a metal detecting channel, but it was dormant at the time. So, go figure. Anyway, I thought I'd share that with you. So I did wish them the best and tell them, I hope you find a good place where you enjoy watching court cases, because they're really fun and interesting. Trying to remember what was the last thing I sent to the burner phone, says Red. Was it me? No. Shaylin says, I'm unsubscribing due to you not following cases for 5 years. See you, Shaylin. Sorry. No, I'm sorry to see you. No, Shaylin, don't do that. Stay here. I promise. We'll stick around for a few more years. We'll get to the 5. We need more experience. That's what it is. Yeah, so I haven't had the most popular opinion on this case, because I've been sort of different than a lot of people. Like, I think different than everybody. But
When are we going to break for lunch?
Oh well, I do what I can. I think I've got an allergy to something, and I think it's my cat. I don't know why. Well, I do know why. We went out on Friday and got the good cat food. like the gravy and meat and gravy type of cat food, right? What do you call it? Wet cat food, right? That's what we call it. Because my kids have, they felt bad that Kiki was resorting to eating squirrels. And so we got the good cat food. I sound bunged up. Yeah, a little bit. I've got my eye that's doing something, and my nose is just, it's not sure if it wants to just be stuffed or runny. So we'll figure out. Anyway, got the wet cat food, and so we've been feeding it wet cat food 2 or 3 times a day. And now he just lounges on our porch. He doesn't leave. He's like, this is home now. So I went out and pet him for a while, and now my eyes are like really scratchy. All right, a couple things we need to mention. We did get started a little bit early, but we do have some things to do in the morning before everything begins. So we'll get some of that underway. First of all, Kelly H. gifted a membership. Thank you very much for your generosity, Kelly. Angela, member for 20 months. You hit the OG mark. 4 more months. 4 more months. And you'll get that pink courthouse, which will look so good. It will match your profile picture. I see you're already dressed to match it. It looks great. Denisha Blyther. Been here a lot longer. I've been with you since Cavalcante. Love the community. Oh, that was a lot of fun. I debated. It's been a while since we've done a public interest type news thing, and obviously there's stuff going on right now which is similar to what we've followed in the past, but it's all politics. I'm just not sure if I want to wade into that one. So we're steering clear of anything happening in LA right now. Lucky comes in with the super chat saying mudlarking on the Thames in a couple of weeks. Cycle over on your new bike and join us. Oh, I'm so tempted. I just need some Wellingtons and some gloves, right? That's pretty much it. I guess other clothing's required, but just some wellies and I'd be good to go. I've always wanted to find a clay pipe with like some stem left over, like the bowl and the stem. Over here in colonial America areas where we metal detect, we find the bits of the clay pipe that are broken off. You know, when they had the big long clay pipe, it was like a foot long. The reason they had that was it would fill up with tar, and the further from the bowl, the more solid the tar would get, so that the stem would be full of tar. They'd have to snap off the end so they could still smoke through it. And so you find all these little 1-inch long snapped pieces of clay pipe. But I've never found the bowl with a stem attached. Denise Felden Ersland. Oh my goodness, Denise. 29 months. That's nearly 5 years. Happy Monday. Happy Monday. So proud of this community. Denise, thank you very much. Appreciate your support. One of our original OGs. All right. Good morning. We are a bit early. Well, I was a bit late, actually, come to think of it. I was going to start at 8:30, and I did not, because right as I was about to sit down, Mrs. R.A. said, hey, I just made pancakes. And I'm like, hey, free pancakes. Yes. So I took a wee bit of a break. Malin Isla, don't have anyone in real life to talk to about this case. Well, I'll have to get the plug for the phone. You can call in, but it's not plugged in yet. I'll have to see when my kids can find where that plug went. I have 3 of them. I had 1, and I always needed it somewhere else, so I bought 2 more, and now I can't find any of them. Alicia gifted a membership this morning. Thank you, Alicia, for your generosity. Happy Monday. So we need to add your house to the birthday list of places. This is Slothly Blower. We frequently make pancakes or waffles. That's a staple. It alternates pancakes, waffles, oatmeal. Those are like our 3 regulars. And then when I have time, or like on the weekends, things like that, I'll often try to do omelets, or eggs and toast and bacon and sausage and all, like a full proper breakfast. But because it's somebody's birthday somewhere, yes, I was celebrating for them. I just don't know who it is. Let's see. I believe my subscription went up this morning. 2 months now, though I've been here since Maya case. Dog Lover, in the bottom right-hand corner of the chat window, depending on the device you're on, there might be a membership messages button, and every month you get a free membership message that you can type a message in. It should show you how many months it's been. Sometimes it doesn't. It's weird like that, but keep an eye out for that. That'll tell you, at least on the subscription side, how long it's been there. Kurt is here in chat. Good morning, Kurt. How are you doing, my friend? Hope you had a good weekend. I give my husband and son updates about the case, but they have no idea what I'm talking about. They're like, sure, yeah. Okay. I traded my free membership messages for free pancakes. What's the exchange rate? It's like 1 stack per message, or? All right. Latasha Stoke. Oh my goodness, that was a hard case, but out of Denver, that was an interesting case. I love that judge. We need to find something else with him. Letitia, he was one of my first favorite judges. Let's see. But you need to ask, what happened to the group thumbnail project for the trials? It just became a little difficult for me to track. Red does fantastic ones, honestly, and so I am terrible at loading them, and so Red Pen I think is getting frustrated with the fact that she does a lot of work and then I don't show it. But Red occasionally makes some great thumbnails. I've been basically getting raked over the coals by the YouTube advisors, basically saying your channel can't pick up new people because you do terrible thumbnails. And although we love the thumbnails, they're not the type of thumbnail that will draw somebody who's never seen the trial or isn't interested in and say, oh, what's this? It looks like, for us, it looks awesome. And it's like, oh my goodness, I remember that part and this is what it means. And this is funny. For everyone else, it just looks like a page out of a Where's Waldo book. And so I'm trying to do something obviously I want to help the channel grow, but I want to find a happy medium in the middle where we can share and build together. So maybe we'll focus on that here with an upcoming case. Mrs. Gurns, my cousin's murder trial starts today. Prayers, please. Oh my goodness. Mrs. Gurns, I don't know which way you mean the murder trial. Is it your cousin is charged or your cousin was the victim? Either way. I guess this really illustrates a point that oftentimes we tend to overlook, and that is that we watch this trial and often don't have any connection with them. At the end of the trial, there's a verdict, and we might be frustrated with it or agree with the verdict. But at the end of the day, we walk away. But for others, family members and others, they don't. It's very close to home. Prayers sent your way, Mrs. Gurns. Thank you very much. Dog Lover, I think I found it. Thank you for covering this case, RA. Are we ready for the last week of the second trial? Yes, I think we are. It seems like it's been a long one. Congratulations on the 4 months, Dog Lover. Michelle's Mixed Media Madness, 19 months. Good morning, everyone. So glad to be here. Member for 19 months. I miss my trial buddies, but KR is too much for me. You're not alone there. I think we'll have a lot of people pop back in once KR is done here in the next week or so. Nanny K1224. Welcome to the gal. Nanny, welcome. Nanny K, good to have you here. Now that you're here, I think it's only best that I tell you that you can't leave. It's a one-way door. I should probably had a sign outside. We probably should have something posted, but we forgot to do that. But you're here now. The good news is you're among friends. You'll never want to leave anyway. So welcome, Nanny K. Thank you for your support. All right. Scheduling. Not this week, but next week. I'm going to be gone for 1 day. My daughter's going on her first, girls' camp trip. And I've been invited along to, scare the bears away or something for just 1 day. So I'll be there. She'll be there all week, but I'll be there for 1 day. And so I'm going to bring the Starlink. I'll be in camp. I'll only be a couple hours away, but here in North Carolina. So it might put a little bit of a change in schedule if I have to drive early in the morning. It'll be a later start, but we probably will just go live from camp as soon as we get there. I was live. I went live a little bit from camp last time, but I didn't have Starlink at the time, so I didn't have the ability to download or to bring Court to me and then also push it back up. I only had the live view, which was pushing it back up. It's the same place, same camp, but we'll just be there for 1 day. All right, a couple others. We've got Val Ebley. Did I say that right? Val Ebley. I didn't watch the first trial. Is Bev's behavior the same? She's been fairly consistent. Do you think it's likely there would be a different judge chosen if there's another hung jury? Isn't she retiring soon or something? Is that a rumor? I think for it to switch to a new judge, there would need to be some sort of impropriety or major scheduling conflict. So the reason for the mistrial would have to, point the finger of blame towards the judge somewhat. And last time it didn't. So I think that would have to exist for it to get to a new judge. Britta Aller, thanks for the support. I appreciate each and every one of you. This is a fantastic place to watch trials. 25 months, over 2 years. Britta, thank you. Would not be the same without you here. Also, You Can't See Me says, thank you to URA and all of your wonderful people in chat who've been so fun, accepting, and kind, even through everything we all go through. You Can't See Me, thank you. Thank you very much. Congratulations on the year mark as well. Brand new color courthouse. The orange looks great. Let me do this. Do we have any birthdays that we can sing to? Because we're actually getting really close to court time, and I don't want to miss it. Greeners, 25 months. Redeemable for 1 stack of Mrs. R.A.'s pancakes, no cash value. Yes. Indy Cindy, 24 months, also hit the 2-year mark. I just can't believe I received my pink courthouse. I love everyone. Indy Cindy, it looks great. Thank you so much. Bite Me says, Buttercup sends hugs and butter sugars to everyone. Thank you very much, Rebecca. Appreciate that. And Rihanna, member for 16 months. 16 wonderful months. Love this community. Thanks, Ari. Thank you, Rihanna. Edsel Dog, member for 25 months. So happy to be here. These numbers are amazing. It blows me away. You guys are incredible. Thank you. I think, hang on. Did I miss one? I think I got it. Okay. But we have one right here. Jennifer Cochran-Fent. So we're going to sing to Jennifer and Jean. How about that? Jennifer and Jean. Any others? Amber, if you could put Jennifer and Jean on one page or one chat together for me.
Happy birthday.
And Noah. Jennifer, Jean, and Noah. Since Noah's birthday was yesterday, we'd celebrate it today then. Grace, that sounds great. Jennifer, Jean, and Noah. Okay, hang on. I need to start typing these. I think Amber's at work, and she's doing real work. Jennifer, Jean, Noah. What was any other names? Jennifer, Jean, and Noah. Did I miss one in there? Dennis. Jennifer, Jean, Noah, and Dennis. Britt Bottoms, you're just confusing me now. Hang on. My dog's birthday's in October. All right, here we go. Jennifer, Jean, Noah, Dennis, and Nana Nelly. Everyone, we're going to sing happy birthday here because court is going to be starting here in just a minute. So we don't want to miss that. So, and Jordan. Okay. You know what? Amber, we should come up with a form where people can make these suggestions ahead of time. And that way we won't miss anyone. Fans ready to blow out the candles. There we go. We're going to sing happy birthday to all these people. By we, I mean all of us. So wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor. Warm up with me if you will. La 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 la. We're going to sing happy birthday to Jennifer, Jean, Noah, Dennis, Nana, Nelly, and Jordan. Happy birthday to you. Happy birthday to you. Happy birthday to Jennifer, Jean, Noah, Dennis, Nana, Nelly, and Jordan. Happy birthday to you. All right, we got Jennifer, Jean, Noah, Dennis, Nana, Nelly, and Jordan. To all of you. Oh, let's get Ronnie on here. One verse for Ronnie as well. Happy birthday to you. Happy birthday to you. Happy birthday, dear Ronnie. Happy birthday to you. All right, to everyone who celebrated a birthday today. Jennifer, Jean, Noah, Dennis, Nana, Nelly, Jordan, and Ronnie. Happy birthday. There are many wonderful days. Today is your special day. I realize there are a million places you could be, a million people you could have been with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn some of that back to you, make your day a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, and Bob Evans. Not sponsors. All right. Welcome. Happy birthday. Thank you letting us celebrate as well. Jackie C. Is it Jackie C's birthday as well? We'll do a quick one. Happy birthday to you. Happy birthday to you. Happy birthday, Jackie C. Happy birthday to you. Drum solo. All right. We're getting to the end. We're going to do a big drum solo to finish this one. And all of you get to help in that. I don't think it's this verse, though. It might be. Okay, no, it's this. This is it. This is the end. All right, everyone get your air drum sticks out. Sit down to your air drum set. We're going to bang our toms and then the cymbals at the end to finish. It goes like this. Beautiful. Thank you very much. Happy birthday to all those who are celebrating. Lori, happy birthday on Saturday. Consider yourself sung to as well, please. And free pancakes apply as well. Happy birthday, Lori. Lots of birthdays from out of nowhere. The fan is moving. It was hot last week. We anticipate it got a little bit cooler, but for those up in the area, maybe Lee, maybe you could tell us if it's still going to be hot. Today, I know for myself, we've had just some crazy thunderstorms over the weekend. As a matter of fact, Saturday night into Sunday morning, it was like 2 or 3 a.m. I wake up and it's just like lightning. It's like a strobe light outside, okay? I'm like, whoa, I didn't know there was going to be a big storm. And I pull up the weather app, and it shows nothing in the area, just nothing. I'm like... And then I start hearing the thunder. It gets closer and closer, and I keep checking the weather app, and it shows nothing. And then the sky opens, and just buckets, water just come pouring down. The wind's blowing, whipping. I open the weather app, and we're getting like an inch of rain every 10 seconds. I'm looking out, and the weather app says nothing. No precipitation. I don't know where this storm came from, but it completely missed the radar. But we got like 2 inches of rain off of it in just a little bit of time, and then it was gone. So, all right. Let's see. Super cold in South Africa. Ooh, wintertime, the other side of the world. Hot and humid in Central Florida. It's a little humid here as well, and I need my fan. I don't have my fan here. Hopefully I can get my kids to bring that to me. Army Mom says, happy birthday, everyone, and here's to another 5 years. All right, thank you. Thank you, Army Mom. That 5 years is going to stick with us for a while, I think. That was a funny thing. Very hot in Northeast Florida. I know they had multiple vortex tornadoes on the ground. Was that in Oklahoma last night? A couple areas had a lot of those. You need Ryan Holiall. He's much better. I do like watching Ryan Holiall. The only problem, here's my problem. Since I've started live streaming, I struggle to watch video without also watching the chat. And Ryan Holiall's chat is insane. I mean, on an average day, he's got 43,000 people in there, and they're all talking, and it's just going, and it's a brain overload. I mean, he's giving great information, but his chat just throws me off. Did you see Lee's video posted on the Facebook page of the drive down Fairview Road? I did. That was really cool. Seeing that and seeing the distance, how it looked. The size and the size of the yard and where the flagpole is and everything. That was awesome. Love Ryan Holiall and Max Velocity. I love that they are amateur they're professionals, but they're considered amateurs because they're sort of just doing it on their own. But I love what they do, and the service they provide is just amazing. I was in scooter races over the weekend. Was that just down like at the mall? You saw somebody else in a wheelchair, and you're like, I bet I could take you. Race for pink slips. That's awesome, Selena. Hope your new chair is working great. What kind of scooter? I know Selena just got a new wheelchair because she's got some issues with her knee that we're hoping to get fixed up here in a little bit and get her back running races soon. Lawyer, let's think about the photo of John's arm and ChatGPT. I did not see that. My wife really enjoys watching Lawyer Lee, usually while I'm live streaming. So I can give her a hard time about that. But I'll have to look into that. Let's see. I like Ryan Hall, y'all, especially for the back end, like how he does his radio communications and how he connects to traffic cameras around the United States, and all that. I like the technical side, and especially when there's a bad storm coming my way, I like the content side. I missed Friday afternoon trial. Should I go back and watch anything spicy? Mm-hmm. Yeah, you need to do that. Sorry. Hope you got some spare time, Charlene, because it was a good one. We're picking up with the same where we left off. It's still cross-examination with Dr. Wolf, right, from ARCA. So Mr. Brennan's going to be cross-examining. He's probably going to back up and cover some things before. And one thing which we haven't really seen a lot of objections, or at least I don't think this is what the objection was during this trial. We haven't seen many objections for asked and answered, right? It's been... Most of the objections have to do with leading or, whether or not the material is allowed in or something else. Asked and answered, I think, might be an appropriate objection to make early in the day today, because I think Mr. Brennan wants to go over and sort of like regain the grounds that the jury might have, faded in their memory over the weekend. So. Roman ADCC, member for 19 months. I have a friend in Oklahoma. Their storms have been nuts there. She just missed a tornado last night. Thanks for 19. Just missed is that's a good thing. Just missed. It's not like, I should have seen it. No, you don't want to see tornadoes. The further you can miss them, the better, unless you're weather watch, of course. Mert Birdwater says, beautiful morning, y'all, from Mexico. Welcome, Mert. Good to have you here. I remember a couple of Bevs saying maybe we'll get an answer this time in response to AJ objecting on and asking it. There have been a few, but I think we'll see some this morning. That's my call. Kayla Newell, so glad to be back today. My son is on his first summer break and has severe ASD. And we're having lots of learning curves. Shout out to SPED teachers, special ed teachers. They're a different breed of people that are just special in a wonderful way. Love it. You'll get into the summer routine. It's gonna be great. Then it'll be hard to go back to school when it's over. Brennan was done, and Jackson started the redirect. I guess I was ready for a weekend before the weekend even started. My brain checked out on the last bit. So but it's still Dr. Wolf, and then we'll have, I know we're going to have another cross. So we'll see. Kaylee, you're going to do great in court. You're a pro at this. It's going to be great. We do have Amber sent us a video. She sent me 2 videos, but it was a pro se appearance in, is it Kansas? Judge Webster's area? It wasn't Judge Webster. The next appearance is in front of Judge Webster, I think. I've got the pro se. I can't show you the other one because it was like the defendant's personal YouTube video. I don't want a copyright strike, but anyway, it's good. We might show that here this week if we get a break or something. Drama Llama Mama says, wow, my phone and computer were perfectly in sync. It takes work usually to get that point. Drama Llama Mama. Imagine having 3 devices, I usually use Apple TVs, but having 3 devices all following a police chase out of California, with each helicopter camera being a different angle and having to sync them up at the same point live so that you can show all 3 on the screen. And again, that's when it gets fun. That's when it gets fun. All right, Shaquille O'Neal, member for 14 months. Morning, y'all, from Wisconsin. Thank you. Is it the Yes, it's the Sovset Pro Say. I think Mike, Law Talk with Mike had it on, but we've got that one. Kim says, I texted you the lawyerly ChatGPT with John's arm. It's very interesting. She asked ChatGPT if it knew who that arm belonged to. Oh, that's crazy. Let's see. I got a question. How long do I see how long I've been a member? I think if you go into subscriptions, it will show you how long you've been subscribed to a channel, right? There's a place on YouTube where you can see how long. My sound is very low. I think I've got a little bit of it's either allergies or a cold or something. I feel great, but I sound funny. All right. The attorney I was prepping with, she and I discussed the Karen Reed case for a few minutes. It was great fun. That's awesome. You'll do great, Kaylee. I can't think of a better name. Member for 4 months, but been around since Brooks, which is basically the beginning. OG. Thank you very much. Missouri here, love the storms. You guys have just amazing storms in the central part of the U.S. I mean, as long as you're not, getting pelted with grapefruit-sized hail and lightning and, your roof getting ripped off by a tornado. Other than that, it's amazing. Do you watch Smoke and Scan? I do occasionally. Great live Chase coverage out of California. He's been covering the riots. I've covered him a little bit. I haven't covered him. I've followed him. Obviously, I'm not a huge fan of the whole smoking part, but and the language a little bit. But he has great sources, and I think he covers some city council hearings that are pretty interesting as well. Happy to recover from college graduation. Stephanie, happy recovery. That's awesome. All right. We're 8 minutes after the hour, so we expect court to start any second now. That would be good. Let's see. If you don't get a chance to watch the lawyerly ChatGPT thing, it says John's arm was injured by an animal. Here's the only problem with that, Kim. And from a technical standpoint, my son does a lot with machine learning and AI and stuff. And you can teach a machine how to think. You teach it by training it. And when it sees something and it's told what it is over and over and over enough, it will then identify that in the way that it was trained to do it, even if it's wrong, even if you trained it wrong. So unfortunately, with ChatGPT, all it's doing is analyzing the internet and seeing what people say about it. That crackle was terrible, but I think we're about to start. And so it ends up being a popularity contest with a democratic vote as to what it is. So it's a good indicator that a lot of people might see it that way or have posted about it, or people that see about it that way have posted on the internet, and ChatGPT is finding those posts and saying, oh, that image means this. But it's not doing the analysis on a deeper level to find the meaning. We'll see if he got out of it. His lawyer submitted a motion. Oh, you're talking about Turtle Boy? Some of the ancillary content that's being created about this trial is absolutely hilarious. The little babies in court. Oh my goodness, that cracks me up. And whoever is it, Auntie Deb, that is like the doppelganger of the judge. Some of you guys just are really, really good at what you do. That's funny because I do see companies hiring for AI training. Like my son does training. We're setting up a camera to do some analysis of traffic, okay, in front of the house. It's going to be able to calculate the speed of the vehicle. We're not doing any license plate tracking, even though it's very capable of doing that. But counting cars, direction, speed, things like that. And using just some video of other traffic and just like random videos, you can teach the computer what a car looks like from different angles. So a car could come this way and turn, and the video of the car is going to look a lot different than a car going that way. And it's now gotten so good, it can pick out cars way out in the distance and see, and just cars it's never seen before. It can identify as a car. It's really cool. No sign of life yet today. We got a little bit of an audio crackle. We've had the camera shake a couple times. We think something is happening in court, but that's all. Let's see. Gender of AI is terrible for artists, needs regulation immediately. I wouldn't say regulation. I don't think it's not. AI can never. It has to base everything on something else. So it's always derivative work. The original idea, the original spark, the creativity is always going to be human. AI does just. All it can do is combine things that it's a derivative of. That's it. So I don't think it will ever take the place of true art, which is amazing. Here we go.
Was now open, you may be seated.
Hi, good morning.
Good morning, and then you froze immediately. Good morning.
So I just saw a transcript that was placed here on maybe referenced this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right.
We'll have to do it before Dr. Rentschler.
So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this? Okay.
With regard to Dr. Crosby and Ms. Coon,
Speak into a microphone.
Sorry?
Speak into a microphone.
Love Miss Little. She's good.
With regard to Dr. Crosby and Ms. Coon, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony. All right. As it relates to Dr. Welcher, the scope of his testimony, our request is that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas, as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolf, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolf and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's all, Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. LaPosada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. LaPosada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in their case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. LaPosada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor.
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. LaPosada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out? Mr. Brennan. I mean, I've gone through it, I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the...
All right, I might have a different page 7. So my page 7, okay.
Top paragraph.
Okay, yep.
Dr. LaPosada proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified.
We're not seeking that.
Great, all right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony, but basically she's not only done autopsies involving dog bites and the wound pattern recognition related to the source of those dog bites, she's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology that she uses. Medical school classes, if I didn't mention the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I won't seek any opinions unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you, okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
I don't know.
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of a jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her an absent from the jury or a voir dire.
No, that's where, if we want to compare apples to apples, Dr. Wolf, Ayden Wolf, was allowed to specifically testify to the wound pattern, or his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the reports, we didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition, at least in his mind, you can cross-examine on it. There is no requirement that the Commonwealth have every single case that Dr. Lomasada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just wanted to short circuit it, but I
So,
have to entertain that.
all right, so let's go on to page 17.
Commonwealth has an objection to the third line. Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that improperly.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Multiple thousands.
So
if she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
So let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to choose.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, we're starting with the first sentence. Yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with a motor vehicle include a component of tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the wound patterns, for instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay, so
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G-forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G-forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, That's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian, incident, or accident.
Okay. So the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We could.
And just for point of clarification, if I ask her, would you expect, I'm just going to make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see a bruise or contusion?
What do you say about that?
I would object. One, it's leading. Secondly,
well, I'm not asking the question.
Secondly, this is asking to have Dr. Lavasada do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Commonwealth v. Tompkins, appeals court. I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Lavasada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another court that she is not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the ARCA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training experience.
I'm sorry, where?
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by a regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
All right. Sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stained pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about blood-stain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify about.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lopesada?
No, not through.
Through whom?
If I could just have, can I do this? With regard to these photos, well, ultimately, the officer will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs?
So he will testify to two subject areas. One would be took measurements from the street to the various entrances to 34 Fairview. I just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior of the garage, including a step and a
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a Bowden defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are photos are introduced on that Bowden issue to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. La Posada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, There's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I would argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car. It means they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative, it is baseless. They want to take that baseless argument and then bootstrap it to Dr. Lapasada to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay. So
the only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house as well.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolf?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Lapasada. All right, bring him on over, please.
All right, a lot of spicy argument here already this morning. Most of the argument has to do with the fact that the defense is presenting a Bowden defense, which is they're asserting that the investigation, the police investigation, was failed, was flawed, was incomplete, was improperly done, or too narrow in scope. A couple different things you can look at that way. They should have looked at this, but they didn't. Because of that, we were calling this investigation into question. Some of this, the judge is protecting and not allowing them to talk about. Some of the witnesses are not allowed to talk about the flawed investigation, which is interesting when that's the defense that the defense is bringing. Not sure how I feel about the pictures that she just ruled on last. These are pictures like inside the garage. I don't know if they're not going to go into evidence. I don't think the jury's going to see them. So they're, I don't know, we'll see. I mean, I know they're not going to get these pictures in evidence, but I'm just trying to think of if they should be, if I feel they should have been allowed in. I think it was probably actually a good call by the judge, but because it's just a possibility, right? That's all defense is saying. We think this is a possibility. It could have been in the house, could have been in the garage. Here's a picture of the garage. Let's see. I wonder if that is good for appeal then if needed. I don't think anything this morning is like screaming appeal. Unless it's possibly limiting the defense in allowing their expert witness to question the thoroughness of the investigation. I think that should be coming in. Voir dire is going to be interesting, especially because we get the impression that the judge already is not really keen on letting this one in. And she's already said she just wants a quick voir dire. We're going to get it during the first break, probably around 10:30 or so today. She's already allowed one dog expert in. She doesn't want to allow another one in. I don't think it's coming in. Don't be surprised if we get an extremely narrow ruling as far as what she's allowed to testify to, or basically nothing at all from her. All right. For it to scream appeal, you'd basically have to have a decision made by the court that was flawed, that is either inconsistent with case law, inconsistent with the law, and can be demonstrably presented to the appellate judges. And the mistake had to have been of such a nature that it would have changed the outcome of the case. It's a high bar. It's a high bar to reach. You can write it in an appeal, but that doesn't necessarily reach the the standard that it's is granted. I think the problem they have with the defense has with the theory that he was in the garage is with the phone movement tied to the temperature. The phone didn't ever move from that last position until, 6:30 in the morning when it was picked up. The phone had to be there very early on after she dropped him off, like extremely early on after she dropped him off. He would have to have dropped the phone or something on the way into the house, or thrown the phone, or the phone got thrown, and then his body has to end up on top of it. That's going to be a tough one to piece together. That piece of evidence, I've said before, is very key to this case. We didn't have it in trial number 1. So it sort of locks down the timeline, because the phone typically was with the body. And if it's not with the body, how does it end up again with the body at the end? Karen, I can see the alternative theories here, definitely. It's funny because my opinion right now, if I were on the jury, I would vote not guilty for Karen Reed, and I would do it for a different reason. I believe the prosecution has shown a very strong case. A lot of circumstantial evidence, but a lot of it is very, 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 very good for their case. The problem I have is the Proctor problem, and some of the witnesses who have no dog in the fight have testified, specifically the police officer who stood out in the back of the car looking at the taillight for 20 minutes, that the taillight pieces were not as damaged extensively as it was, currently. The only thing you can conclude, if there was taillight that he saw when the cops took him into custody and that was then later found at the scene, was that they were placed there intentionally, or claimed to have been placed there or found there by Proctor. And that is a problem. That is a corruption issue, even if it's just one individual.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Okay. Good morning again, counsel. Good morning, jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning, so thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Okay. Can we have Dr. Walker, please?
Dr.
Mr. I'll remind you, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolf, thank you for joining us again this morning. I'd like to draw your attention to a picture. May I approach, John?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes.
You were shown this photograph last week, is that right?
Correct.
By Mr. Brennan, correct?
Correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes.
Under questioning by Mr. Brennan?
Yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes.
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court order.
Exhibit 218.
He did his own slurping sound effect.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
Yes.
This is the road rash, the opposite arm, not the one that was struck by the car. This is the left arm of the dummy, not the right arm. You can see the skid marks, the black stain, the scuffs. Let's see if there's...
Dr. Worrell, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face? What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself, on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. The second image I'd like you to take a look at. If we could have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Okay. Exhibit 219?
Permission to display?
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
Okay. The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
If we can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220?
Permission to display?
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso?
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Poor Randy.
Yes.
Are those the chin and nose defects that you saw?
Yes.
He lost like a quarter-inch off his nose.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize, do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Bodice is only on a dress, AJ.
Yes.
It's
And what about, let's go back to the full frame.
chest area of a dress.
Is there also road rash on his jeans?
Yes.
If we could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy's shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
Watch the form of the question.
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
We can take that down. May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at?
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay.
I hope they got
222.
vehicle warranty. Extended warranty with their car.
Permission to display that?
Yes.
'Cause this one's not going to buff out.
Is this the photograph that we were just talking about?
Yes.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the Hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the Hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The Hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist?
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. That's not a, is that a physical arm? You can touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between 11, well, what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the kind of the final number he landed on.
Does
Sustain, just ask the question, stop striking the end.
Does 11.86 sound right?
Yes.
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
1.26439.
You're looking at just the difference between those two?
Subtract
okay.
9.38.
Yep. 2.48.
Oh, that's the.
Is there a does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm that from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Objection. Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Objection.
Sustained.
Is 23% smaller or not or larger than 26%?
Objection.
Sustained. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
0.21.
In percentages?
21%.
Thank you. Was the hybrid 3 arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
All right, I was going to go give my son some guidance. Loop, 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 loop. That's freaky. Some guidance on fixing the bathroom on the remodel, but sidebar instead. It's funny, the judge says, go ahead and move on, Mr. Jackson. You've pointed out that Mr. Brennan did the math wrong. Just move on. So, all right. Said bodice twice. Is it math guidance? Yes, measurements. Cutting gypsum board. So it's objectionable because this line of question is attacking the prosecution, not redirecting the opinion. Yeah, there's a right way to do this. I think he's already covered the right way, and that's good enough. Brennan related difference in mass to actual speed 2. Hope they point that out, says Dale. All right, let's see what the judge's decision was here. Oh, Mr. Lessie left prematurely. He's back. Now he's leaving again. Maybe they're going over the math. Which formula is the correct way to do it?
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it. Sorry.
Not yet.
You see it now?
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolf?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the formula. Ask it differently.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Would that have a material difference? With the weight of the arm, that 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests, okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Day one of
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You
Your
understand?
Honor, may I have a pen and paper to write?
May I approach you, Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay, whatever's easiest.
He's going to show his work. This is going to be admitted.
If you
as
assume
evidence.
the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared.
Correct.
Is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Just nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm.
Okay.
That's being transferred.
Understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
Mr. Brennan
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38.
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5.
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Objection.
Sustains.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29 mile an hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right?
Sustained.
Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying
Somebody
on
else does
body
that.
weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is...
So it's sustained. Ask the question differently.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated for use for that size man? Where is that?
Again, It's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50th percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less, true?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
You have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50th percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that, or answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused, I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I don't have the percentage off the top of my head.
So if you take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50th percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds.
Okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%.
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8 or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes.
You testified before under oath in this case, didn't you?
Correct.
And when you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Objection. Sustained.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just did the math, didn't we?
Yes.
Okay. And you used a calculator to help you, didn't you?
I did, yes.
Calculator works?
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
didn't ask you. I'm asking if you would agree with that.
Can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier, is you would increase the mass, you multiply it by the acceleration, that's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm, yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you changed the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummies arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No.
Okay, so, no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
Right. And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human that pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones that you use for test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever?
Okay, this is crazy.
No, I know a lot of it.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yeah?
Correct.
The other one testifying, giving opinions to this jury, yes?
Yes.
The other one asking them to rely on your experience and training, true?
Correct.
The other one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes, and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024?
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection is sustained.
I'll move on.
The objection is sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the taillight cover?
So I'm going to see you inside.
Mr. Brennan doesn't get that the line of questioning is to think what was sustained to this objection, and I don't think he's been able to go here. He wants to question Mr. Wolf on the parts the other person did. It's much easier to question Mr. Wolf about that because that's not where his expertise is. I'm going to just say I've just been counting here in the last couple minutes, and between 1 in 10 and 1 in 20 messages are having to be deleted by the mods. I don't pay them, and they shouldn't have to work that hard. I'm just going to instruct the mods that if you have a message that needs to be deleted because you're calling someone a name whether it's Mr. Hank Brennan, whether it's the judge, whether it's the witness, anything. If it's a name that they haven't introduced themselves by, or a nickname they say they go by, you're going to sit in the corner for the day. Okay, it's too much work for the mods to have to just constantly be deleting names. We don't need to call names here. Okay. The Screaming Goat is on sale. That's awesome. Yeah, first name, last name, they're okay. Hank, Brennan, they're okay. Derivatives, combinations, rhyming words, derogatory words, not so much. I'm a little bit different. I'm here to defend myself, and we're guests watching court, so let's just be respectful. I realize we have people with different opinions, and realize that each of us looks at this and we see it a certain way. We're far enough along in the trial that I'd be surprised that there's anyone out there who's like, well, I just need more information. Then I'll decide where I stand on this. A lot of people have formed an opinion at this point in the trial, are viewing evidence and testimony that comes in based on that opinion, and consistently finding that the side that they have chosen with is constantly doing right, and the other side is constantly doing wrong. Just understand that there are people who've gone through the same process that you did, came to a different conclusion, and feel just as strongly the opposite direction, and view it the other way. We don't need to try to convert everyone to our opinion, and we don't need to yell into the void every time we think somebody's doing well. If you're finding you have to tag people, you're tagging people back and forth as you're arguing, let's just be nicer. Let's be nicer. Orlean, is it Aurelian? Welcome to the gallery. I don't know how to say your name because I failed that English class. There are a lot of people who have watched a lot of the court and have missed parts. And there are some people who have watched a lot of the previous court and are basing things off evidence that came in the first court, but not in the second one, a trial, I mean. Sorry, I'm often mistaken about things I say as well. Let's give people grace and space. Let's see. It's an unsanctioned name, but is Crash Daddy now banned? We have allowed complimentary nicknames generally, but if it gets really crowded and distracting, we'd cross that out and say let's focus on the testimony. I'm curious. What is the punishment that can happen? What can the judge do if one side or the other continues to add commentary to a question? And I say that because both sides have been doing it. But if one side goes too far, what can the judge do? Can the judge cut off the questioning of the witness and say you're done? No more cross-examination of the witness. I think that would be definitely something that could be brought up on appeal if it's the defense, because they have a constitutional right to question a witness. But what's the corrective action other than just sustaining and striking the question? You can't really unring the bell. DSN, thank you for the super sticker. Love the game controller there. Is Brennan a mob lawyer? I don't think we have mob lawyers anymore. We don't really have mobs anymore, do we? Sanctions on counsel and mistrial for defense and prosecution. But the sanction, I'm wondering, as far as the sanction goes, and I realize mistrial for egregious problems, but what would the sanction look like? would it be you're not allowed to go into, you're not allowed to bring up a certain witness, or you lose, we've seen like in civil cases, you lose X number of hours of time cross-examining? Or is this like a punitive punishment? You're going to be fined $1,000 when court ends. Oh, yes, we do what? What do we do? He defended Whitey Bulger. Yeah. We've had a couple lawyers who have defended people who socially it's not acceptable, right? But at the same time, my belief in the justice system includes the belief that everyone is innocent unless proven guilty in court, and everyone is entitled to a lawyer. Somebody has to defend them. I don't believe that because the crime someone is charged with is particularly egregious or, socially, it's unacceptable, that they should only get a really bad lawyer because they should be found guilty. That goes against the sense of justice. I think people who are charged with very bad, heinous crimes also deserve really good lawyers. And they have the right to go to trial and to have the case presented against them, and the prosecution be compelled or carry the burden to prove them guilty in a court of law. So I don't like judging an attorney based on the clients they've had previously.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side, yes.
And so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if I
when
understand.
Drag, push. how about we use the word push, pushed by the broken taillight? Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved with the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage to the that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity?
The operative word here is push. And so do you like to agree with me or you could disagree with me? Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding Test F, now you use Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Okay. And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. In the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Okay. Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
In finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
It's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you talked about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection.
Beyond the scope, Mr. Brennan.
A few more questions, Dr. Wolf. You showed us holes in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir. Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor.
Third time for AJ.
If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
Objection.
The objection sustained.
You were asked, give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man? Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
Objection.
So that's sustained as to form.
What did Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
That's funny. And then he did the math to calculate for the right size, just like they did.
You were also asked whether or not using that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm, area of the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%, did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
No.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection. So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were?
Objection. So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know. He was asked questions.
That's the end of that, Mr. Jackson.
Whoa. He was asked questions and
Mr. Wolk,
answered.
do you have the picture of the tin? The TIN, tin, the little round tin?
I think he should have been allowed to go into that. Because he did ask and answer questions after.
Do you see that tin?
Not knowing what they were.
Yes.
Are you aware that all those pieces are inside that tin?
Objection. Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins about 2 inches wide?
Sustained.
Move on, AJ.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
Okay. In your testing, how long did it take the hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test? About?
It's like
about 10 milliseconds. Very,
I'm sorry, say that again, louder.
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight
Little lag here.
fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
Follow-up questions.
Okay, go ahead.
Hardness of the arm. Is that we're going to approach. Oh, man. The observers in court seem to indicate that the jurors are taking more notes during the time that defense has been questioning Dr. Wolf this morning, and some even yawning and appearing disinterested during the prosecution. Don't know if you can read everything into it that a lot of people are doing, but that's the reports from Sue O'Connell this morning. I liked this morning. I liked both. I think Mr. Brennan scored some points in this, getting some things admitted. Some of the responses from Mr. Wolf are consistent with the prosecution's theory, and but I think generally, Mr. Wolf has been a favorable witness for the defense overall. I'm really interested in seeing how Dr. Rentschler is going to answer these questions, knowing that he's going to be hit really hard, particularly on the idea that they used a crash dummy or a rescue Randy that has arm material significantly different from human flesh. That line of question, I think, is going to be ripe for the picking for Mr. Brennan, especially in light of the fact that there appears to be case studies or scientific literature out there that supports or speaks against using the type of dummies that the ARCA used for that very purpose. Yeah, Dr. Welcher is not the case law, not the source on that one.
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is...
Ask the question.
If the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. You agree with that?
Objection, about the source.
No.
Dr. Rentschler, do you agree with that?
Objection.
Oh.
So I'm going to allow it, strike the source.
Do you agree with that?
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage. Specifically, if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with that?
I'm going to allow it.
No, we need to approach. I need to approach.
Objection. I'm going to allow it. Your Honor, we need to approach. I need to approach. Alan Jackson's like not liking this. This is Mr. Brennan crossing Dr. Wolf with his coworkers' statements that maybe in this report or maybe in some other report. But the statement that Dr. Rentschler made in whatever source it's coming from seems to be inconsistent with the idea the defense wants to put forward. So it's much easier to question Dr. Wolf on this than it is Dr. Rentschler. Dr. Rentschler might understand scope or outside context to the question that this one doesn't get. So you don't get his point. What Mr. Brennan's trying to say is that when the taillight hits the arm and the taillight breaks, let me move right here, hits the arm and the taillight breaks, as it's pushing along, the force of the car is pushing these broken parts of the taillight into like beneath the surface of or against with pressure the arm. And then as it's in that position and the body is eventually separates as it can either fall or due to gravity or as it rotates or pirouettes out of the way, that can cause a scraping motion. He's trying to get to explain how those linear abrasions could occur, and it makes sense, but he needs the expert to agree to it, to say, couldn't it be this? I don't believe
I'm going to read this one more time, okay?
The broken pieces can do it. It has to be the pieces that were not broken. But then
Would
you have
you
a problem
agree?
with no DNA on the taillight.
If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please.
Roll tape. Look out, Randy, look out. Randy! Dang it.
And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Doesn't he spin like a pendulum?
If it's just the arm, his arm's going to get accelerated move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess.
All right. Wow.
Please rise for the jury. Right this way.
Mr. Brennan seems to think that the way he's trying to explain it is that the forklift holding the straps that were supporting Randy in an upright position acted as a rod driven down the center of his body, anchored to the ground. I think we would have seen his legs fly out and spin. I don't think Mr. Brennan's right in that suggestion. But they got a break. We don't. We should have voir dire here during the morning break.
All right, so we're not going to do the voir dire right now of Dr. Lapasada because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the director, Dr. Lapasada? Is that you, Mr. Jackson?
Yes.
All right, so what I would ask you to do is not do anything on your direct examination with Dr. Lapasada that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire. But I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you?
About 30 seconds.
To use the hour?
I can get her credentials, but Your Honor, half her credentials are the fact that she's an expert in dog bites and an expert in motor vehicles. I can get her education, training, background. But
Okay, is that all in her resume?
It's all in her. It's all going to be in her direct examination.
No. My question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says the word dog bites anywhere in her resume. No.
We have absolutely no notice.
But the courses that reference dog bites are listed here.
Say that again?
The courses that reference her teaching dog bite issue and pattern recognition, they're listed in the resume.
All right. We'll see you at 12.
So we get a break. Judge proves me wrong once again. Thank you, Judge. Appreciate that. It should be in their CV. This is a bit of a surprise. Mr. Brennan is saying we did not get any notice that she was going to be talking about this issue. And because of that, they should not be allowed to bring it up. Dog bites, car crash, none of that. Well, that's all they're getting her in for. So the judge making this call saying we're not going to do the voir dire. How does she say it here? Voir dire. Every judge says it differently, and I swear everyone thinks they know how to say it, and everyone doesn't. Voir dire. I think it was what she says. Voir dire. We're not going to do it right now, but go ahead and start your direct examination. Mr. Jackson's like, with all due respect, Judge, that would be like not asking Dr. Wolf in the initial, say, half hour of discussion if he does anything with crashes and reconstruction. This is what they're all about. So we'll see what's going to be allowed in. Hannah says, Brennan gets so caught up on the silly things that by the end of it, his good points that were made, if any, are watered down and ridiculous of his continuous questions. He does pursue doggedly a specific point. And I think it didn't land as well as he hoped it would. If we go back, let me see if I can show you this. Let me give you an example. As my kids are about ready to start sawing something in the bathroom that's really loud. All right, give me a second to pull this up on camera 7. All right, today's video. There it is. There's a certain part of question I want to show you here. Okay, here we go. Let me make sure you get audio, though. You guys see this? You can see that? Watch Mr. Brennan's eyes here, because he's doing this for a very specific purpose. We're going to replay just a couple minutes of this testimony really quickly.
Pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is...
So it's sustained. Ask the question defendant.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph.
He keeps looking over at the jury, and he glances back and forth and back and forth and back and forth at the jury at this point.
That depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of...
He's trying to read the jury during this testimony.
Of, according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you some very...
So that was quite interesting to watch him do that. He's obviously very mindful of the jury's response to the question. And
simple question.
Oops.
Dumb it down for me.
We don't need any more. I'd be uncomfortable if I was on the jury. I thought those are eye rolls. No, you can see him glancing around at different people on the jury and the whole thing. Hey, who's here? Right. Keeps rudely pushing. I think he's trying to illustrate a point. He wants to illustrate the fact that he's asking a question and the witness not answering. And he wants it to come across as a very clear, very straightforward question. Yes or no? Can you answer this? And the more the witness doesn't answer, the more it looks like, hey, maybe he's not being truthful. We need the AJ head explodey comment as a command about the math. There's just too many people talking at once on that one. I'm not sure if I can isolate that. Can someone check if there was a decision on the restriction to the jury about missing witnesses? I don't know if that decision was probably denied. All right, there we go. Cable found. We need a break as well. You can have a brief break. We've got till noon. We'll come back at noon. We need AJ's stop it comment. Judge Beverly is not behind on our homework. It was stuff that she was just given this morning. So, just last minute stuff. I don't think there's anything about a planted juror. I don't believe there is. First of all, the jurors have all responded that they have not seen anything, have not talked to anyone. That includes each other. They're not allowed to talk to each other about the case, so they should not know at any point what anyone else in the jury is thinking, aside from being able to read body language of people sitting next to them. I always believe, unless there's evidence to prove otherwise, that the jury is in fact following the instructions they were given and the oath they took. It's my belief that as a juror, I believe I would do the same thing, and I give them that same benefit of the doubt. So unless proven otherwise, I discount all those allegations. Or what the clerk is thinking. The clerk's a little easier to read now, Goodman Law. She's a little teensy bit easier. Carla Westbrook, I am not an attorney. I'm a law tube adjacent is what we like to call it. I've had a lifelong interest in the law, but my career has taken a different path. I worked for the government most recently before I started doing this. For the Department of Defense, held top secret SCI clearance, did lots of really cool things I can't tell you about, and enjoyed that. But ever since I was probably in junior high, I liked learning about the laws, I liked studying, reading the laws, reading proposed laws when they were bills, and studying court cases. I'd go to the library and check out transcripts of high-profile court cases. So it's been an interest of mine for a long time. Frida B, member for 26 months. Pink is my new favorite color. Thank you, Frida B. Congratulations on 26 months. Let's see. I believe RA is doing this as an undercover. Let's start that rumor. No, I'm not. RA hid law books inside his comic books as a kid. Yeah, didn't want anyone to steal them. Nope, never worked for the CIA or the FBI. I almost worked for the Secret Service. I applied and got a job offer, and I turned them down. So, but I almost did, but it didn't fit my lifestyle, which included being married. Will the jury be allowed to take their notes into deliberations? Yes, but the notes will be destroyed at the end of deliberations. They don't get to take them home with them afterwards, but they are allowed to bring them into deliberations. Currently, they don't have them with them at the end of the day. The judge takes, through the bailiff, takes custody of those, and they're returned. The notes are returned to the jurors when they come back into the courtroom. Laurie, I'm not going to sell the taillight. I do fully intend to destroy it. I do have 2 bug assault devices. I used one just the other day. Red, I've gotten really good. Bug assault is it's like a toy gun, like a squirt gun, only it shoots salt, and it's designed for shooting pesky little bugs, not people. You don't want to shoot at a person. But it's pump action. Red, you sent me 2, a pink and a yellow. And yellow is my favorite. I'm better at aiming. I'm able to shoot flies out of the air just as they're buzzing around, just pow, and just drop them. I don't have to wait for them to land. It's really cool. When are you destroying the taillight? I don't know. My bike arrives in the next hour. I'm supposed to be building that tonight. I'm also supposed to film a city meeting tonight and broadcast that on Facebook for the city. I'm not sure if I'm going to be able to do that one. I just don't know when I can do it. And in all my spare time also, I need to be working on the bathroom remodel because it's taken like 6 months. And it shouldn't have taken that long. Let me send you a link to the bug assault. Hang on one second. This is if you don't like flies as much as I don't like flies, these are the most amazing devices. Okay, there are a couple versions. The 3.0 happens to be my favorite here. That's the one Red sent me here. link's not working. Wait for it. There it is. Yeah. All right, there it is. There's the bug assault. I spelled it wrong, but close enough. It is salt. It uses table salt to shoot. They make great Father's Day gifts. Oh, they're amazing. Oh, my goodness. They're so good. They're so good. It's a risky click. That is an affiliate link. If you do make a purchase after clicking the link, Amazon may reward us with a small financial incentive, generally amounting to pennies, but it would be much appreciated. Whoa, this is big. Sue O'Connell's reported that during this recess, the defense team has had John O'Keefe's hoodie out of the frame and are examining it. I didn't like the clothing being in the frame. It ruins the collector's value. Yeah, I think it ruins the ability for the jury to perceive the shirt and really analyze it properly. And Bree says, checking out how to spend those coins in one place. Next month, when they give me those pennies, I'll think of you when I give them to my son for killing bugs. Where does a person see Sue O'Connell's updates? Rexy, she's on Twitter. That's where she posts. So you have to sort of go over to Twitter to see those. Let me see what hashtag she's using. She's not using hashtags, which makes it a little harder. Her handle is @SueNBCBoston. @SueNBCBoston. She's affiliated with Boston NBC 10. But she's here as a commentator, not a reporter. The judge wants the defense to start redirect and then do voir dire at lunch. We're so close to lunch. I mean, we'd start in 5 minutes, but... Amanda, if you click the link and then make a purchase of something else on Amazon, it should, if it's in the same visit, it could give me a referral incentive for both, because it's a referral for sending someone to Amazon, not necessarily a referral to buy that specific item. So if you used a referral link and accessed Amazon and then bought, everything in the world, it would probably give me a substantial referral fee. Meg, they are so much fun. Just use iodized table salt, just regular table salt for it, and it works well. It doesn't show me what people buy. Nope. Where's the link, please? The link is... Okay, right there. That's the link to the bug assault. It is an affiliate link. Pat, I'm sure pretty much everyone in this trial has an opinion at this point. We're very close to the end of the trial, and so I'd be surprised if people weren't leaning one way or another at this point. She is just here as a commentator, not a reporter. Greeners, I sure don't want RA to broadcast that I just searched gnome garden accessories on Amazon. It showed up as fairy garden on my Android. No, just kidding. Just kidding. You're good. I don't get to see what you search. By intimate, I mean laundry, detergent, and batteries. Right. Uh-huh. Gotcha, Greeners. Gotcha. The clerk used a box cutter to unseal the sides. Jackson has gloves on and has taken the hoodie out and is examining it. Andrew N., glad you got to watch with us on your day off. Hope you also get to do something fun. I mean, in addition to just watching court and not working. Y'all would love my gnome garden. I have a T-Rex devouring the gnomes. It's a horror scene. Red, send me a picture. We'll share it. That sounds awesome. And do you have any succulents in your gnome garden? I ask because here in North Carolina, we have a native plant that is carnivorous. The Venus flytrap is native to the Wilmington area of North Carolina, where I'm going to be camping here next week. So I'm specifically going to look out for Venus flytraps, although they don't allow you to dig them up. You need some succulents. I think it's actually a requirement for a true gnome garden to have a succulent, miniature succulent. Adam might be able to hook you up. Venus flytrap is nature's bug assault. If you ever watched one work, they're fascinating. As long as you don't put yourself in the mind of the fly as it's getting strangled and digested alive. But good stuff. I want to, while I'm going camping, I'd really like to go metal detect White's Lake. White's Lake is an interesting little lake, completely surrounded by homes and businesses. And so almost every single square foot of shorefront footage is owned privately. But there's a couple places where you can, with public access if you pay to get in. And might go metal detect there. I'm in North Carolina. Lacey, question for somebody who has a Venus flytrap, do you feed it? I mean, I know you're supposed to water plants, but do you water the Venus flytrap, or you just open the window and let flies in? What's the right thing to do? Does it get all its nutrients from the flies, or does it need water and then it has a secondary diet of bugs? As a kid, we fed it steak. Seriously. Hoodie's going back into a white plastic bag, according to Sue O'Connell. Sue is giving updates right now. Jackson and Brennan both put on black gloves. Brennan puts the shirt in the bag. The bag is on the floor in front of the spectators section. Brennan is on the phone. Uh-oh. Wonder what's up there. Mr. Brennan making a phone call from the well of the court. Moments before we come back from break. So, full confession yesterday. Went to church. I was so tired. I was so tired. I have the ability to fall asleep very quickly, and then I also have this wonderful gift that when I fall asleep, I announce it by snoring quite loudly. And so I'm tired at church, and instead of going to like a class, a Sunday school class, or anything after, as I just sit in the foyer on a couch. And a friend of mine who lives nearby goes to church there. He's out there as well, and we talk a little bit. And I sit down, and I've got my laptop on my lap. I'm doing some stuff, and I know I'm tired, but I'm like, I just close my eyes for a second, then I open it again. I'm like, okay, I'm not going to fall asleep. Not going to fall asleep. My son comes out of his church class, and he's laughing, and he's like, Isaac sent this to me, and he pulls up a video, and it's me like just sawing logs fully upright on the couch. I had no clue. He like filmed me and then sent it to my son. Like, I have no idea how long I was out, but now I have to bribe them to get rid of that video. But, oh man. Love it. No, we don't need to see it. We don't need to see it. I was like upright. You couldn't see because he was maybe 20 feet away from me when he was filming. I couldn't see in the little video if I might have even had my eyes open, just like full on sleep, just in the position I am right now. And but man, I was snoring so loud. Did anyone sharpen your face? No. Fortunately, no. Tell your son I have some Bitcoin in exchange for that video. It would have to be Bitcoins, Ivan. Bitcoins, plural. That's the price. Anyway. Narcolepsy, I don't know. I'm sure something's wrong with me. Sometimes I'm just exhausted, tired, and sometimes I go like all week. It's like every day I'm just plenty of energy, and then the weekend hits and it's nap time, and I take a 6-hour nap, get up for 2 hours, eat dinner, stay up for another hour, and then go back to bed for another 8. So it's worth it, Ivan. It's worth every coin. Speaking of coin, Ivan, I did the math on the Bitcoin that I have saved, and I believe it has been. Let me do this here. Let me do the increase on the value. Let's see. My initial investment, which was gifted to me, has grown 120 times the initial investment. 120. And since 2014, I don't know any other investment that has grown that much. Lenovo gave me some as well. I do have some. I'm hodling that. You need to sleep study. Scared to see what they do. First of all, I can't do one of those Darth Vader mask things to sleep. Check your sodium levels, high or low, because I'm sure they're high. Yeah. Anyway, nothing else exists. It's crazy how much has grown. All right, we're back.
All right, so I'm told counsel wanted to see me.
Your Honor, issues has arisen related to the cross-examination or recross-examination of the last witness, and Mr. Alessi would like to address the court in detail about that.
All right, so the last witness was your witness? Is there a reason?
This is a separate issue, and I'm asking Mr. Alessi to address the court on this.
Okay. What do you want to tell me, Mr. Alessi?
And make it brief.
Bear with me a moment, Your Honor. I need to put on evidence gloves.
Ooh, for dramatic effect, black gloves. Lick them. It makes them easier to put. No, just kidding. Don't do that. Don't do that. Shut the door behind him. Mr. Lessie puts on the small gloves, which are nice and tight. I think the problem is, Mr. Brennan said there were holes on the back of the shirt.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked...
He's grabbing everything with those evidence gloves. Usually you put them on right before you grab the evidence.
What I would like to have marked, the first document...
Mr. Brennan was on the phone.
I want to get the specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
He said they were holes from road rash.
Exhibit YYY.
If it was cut out by the crime lab, and he knows it.
And may I see that, please? Thank you. Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ for identification.
Give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay.
Did you consider these holes?
I can't tell entirely from ZZZ, but if that's your argument, why for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Mr. Brennan.
Thank you, Your Honor. Thank you, Madam Court.
Do you look nervous, Mr. Brennan? Still has the gloves on.
Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
Absolutely,
Mr.
Your Honor.
Alessi.
So here is the back of the hoodie.
Okay. All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist, and I'm going to get to back to this in a moment. But I would like to do it, and certainly entertain any of Your Honor's questions, but in a logical order.
Sure, so I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your
Then
Honor.
the jurors can be sent home for the forever. Yeah.
All right, thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here and the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
Ms. Little?
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-218-4. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see. Point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various... Let me just get a check on this, Your Honor. I'm not...
Mr. Brennan, you should come up and look at this.
Mr. Brennan, you should...
So Mr. Leslie, stay here.
Yes.
All right, so this is why. I didn't see where Ms. Hartnett said that she cut it off. It was showing here, Mr. Leslie says exterior front.
Can I get the check?
Labeled cuttings.
Pardon me?
They're labeled cuttings.
Right, but if I can, Your Honor,
Sure.
I want to clarify this. Yes, are you willing just to want? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, yes, a second. It may have printed the wrong page. I can do it, but Mr. Wolf, can you print the back? And then, Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will.
He's printing it right now.
Printed the wrong one. We need to mark it. Mr. Brennan leads to Mr. Lally. Said, how did I screw this up?
We printed... We wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
Oh, if they get a mistrial with prejudice, the trial is over. She cannot be charged again for these same crimes. With prejudice means that the prosecution did this intentionally. This is bad. This is bad for Mr. Brennan. First of all, you should know your own case. So him getting up and saying, "Sorry, I didn't know that these holes on the back were not, were caused by our criminalist taking samplings of the shirt." That looks bad, but he had the pictures. He had these marked. This is probably the closest to a mistrial this case has gotten. That's why Mr. Alessi is practically jumping up and down, shouting for joy.
If I may, Your Honor, I'm advised it will take 2 minutes because it has to go...
All right, so go ahead with your argument.
Thank you, Your Honor.
2 minutes to warm up the printer.
So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice.
Which he doesn't have faith in. Otherwise,
On
he
its
would have presented it to the
own,
jury.
to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it get marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
It's going to be another 2 minutes.
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
A. It's like AAA, but with an extra A. We're in 4 letters here. 4 letters deep into this trial.
Sure.
It's different from 4 squared, right?
And here's another document, chain of custody document.
Mr. Brennan has removed his glasses, studying the picture.
Well, Mr. Brennan is reviewing that. When I had to, Madam Court Reporter, the chain of custody document for these, and asked that he mark it as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
BBBB. BBBB is what that one is.
Do you need this, Mr. Lessie?
I do not need either of them, Your Honor, and I have the extra copies as well.
Mr. Lessie is saying, I don't need anything after today, Your Honor. We
So,
believe
Your Honor,
we'll be
I now
done.
have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, Your Honor. Thank you.
I still do not have Z's.
I believe Brennan was updating his LinkedIn.
All right. Thank you. Okay, go ahead, Mr. Lessie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, And Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminal list as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is...
That means they can't fix it with an instruction.
On the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
right,
that.
That's right, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
I want to hear Mr. Brennan's response.
All right, thank you.
Sorry, hammering there.
Mr. Brennan.
Mr. Brennan, let's hear what you were thinking.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right.
That's his mea culpa. So we have a problem.
I'm not going to allow the mistrial motion, Mr. Lessie. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Lessie, what day these were done? Is it all of those 3 days? Now I see a 4th day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates?
Your Honor, on about May 18th, when the defense filed a motion to test. So those are, that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
All right, so I'll hear you. Go ahead.
So the first, Your Honor, is with regard to 2 things. One, I would like the opportunity to have the hoodie sweatshirt held up. Because that's what happened.
Yes. Yes.
These holes
Yes. Yes.
Okay, thank you. So that's number one as part of the stipulation. And then,
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Alessi. I'm not showing disrespect to the court.
Okay.
Of course you were listening.
All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheathing. It might need to be remarked. The plastic sheathing was marked, but if we're going to put it into a bag or something like that, we might need to have it marked. But we don't need to do that right this second.
Okay.
I think the defense...
Yes.
I think they should get something else. It seems only fair that they're able to reference this as it occurred and say they have nothing. They even tried to say that something that they caused was evidence to show there was an accident.
All right, thank you.
I think the defense should get to be able to say that in closings.
Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
So this is Exhibit 223.
In your honor, I would hold it as your honor begins to read. Is that consistent with your honor's expectation?
No, I want you to hold it up with the back.
What would you like me to start with?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott, or the court officer.
Yes.
Thank you.
Court officer.
Bear with me a moment, Your Honor. I'm going to be put on the record.
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here, but she's on next. I'm going to call John T.
For just the measurements?
No measurements.
The judge is big mad. I don't know if that.
You're not going to be able to show the exhibits from Ms. Hartnett or the cuts along with the next after the structure show the cuts that were made by Ms. Hartnett.
Well, I say it, and I'm going to tell her what they are, so.
Defense wants to show the images that show the hoodie in the lab with no holes on the back. Judge says, I'm just going to admit them into evidence. Well, who do you bring? It can be in evidence that the jury doesn't know about it. I mean, it's like, oh, there's some random pictures in here. What does this mean? I think there needs to be some explanation, not just like, oh, and we've added these pictures to evidence.
Please be seated. Court is in session.
All right. Jurors, I appreciate your patience. Mr. Alessi, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag. So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll... Mr. Yannetti, your next witness, please.
John T.
I know your lunches are here, but defense is going to keep you from eating. So they're going to be cold, but it's on defense. It's not me. If I were defense for every single witness from here to the end of the trial, I would bring up those pictures that the judge admitted into evidence but were not shown to the jury with no explanation.
You solemnly swear the evidence you give to the court and jury in the case now is here to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
All right, good afternoon.
Good afternoon.
Go ahead, Mr. Yannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's T-E-D-E-M-A-N.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start forum investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay. And when you say June 3rd, we are talking about last week,
yes,
correct?
Last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right. And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
Can you describe what a wheeled measuring device is?
Yeah, it's like a handle with 2 wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolf, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolf? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes. On the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
And the 2 garage car doors, yes.
4 cars to enter. Okay.
Yes.
We can take that down. Mr. Wilk, and put the lights on. May I
It's a
approach
4-car garage?
Yes.
Or a 2-car garage?
So I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, garage door and the two car doors to the garage.
Okay, particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Mr. Brennan objects, wants to be heard. Judge is still mad at Mr. Brennan because he screwed up and made her give the apology. It's awfully quiet in there. Oh, my mic's turned off. I just heard a juror's stomach growl. Yeah, this should be quick. This should be quick. And then her little snide remark to Mr. Alessi about, if you're not going to listen, I'm not going to read it. Yeah, she's frustrated with the situation. I think she knows it's bad. Oh. Jurors deserve recognition. They have been great. Have we lost any jurors in this one? I don't think we've lost any. I really think there's got to be an allowance to the defense, and it should have been, I think, part of the correction. Instead of just having the judge correct that you don't get the prosecution allowed to have the benefit of the impact of saying you didn't consider this, because that discredits Mr. Wolf, right? And he's like, no, I didn't. That discredits all of his testimony, and then at the end they're like, oh, those holes were caused by someone else. So how do you restore the credibility to Dr. Wolf in his testing? How do you? I mean, I think the jury should hear something about this. Was prosecution presented this, but guess what? They lied. They lied. He screwed up in his brief review of the evidence. Excuse me, Mr. Brennan. Brief review of the evidence. You have been all over this case since the day you were assigned to it. It's not brief review of anything. I don't know what they'll allow it to mention in closing. He made a mistake. I don't think you can just say I made a mistake, so don't talk about it. Might do it during Rentschler. I don't know. It seems that the prosecution gets an unfair advantage, and the only problem about that, I mean, logistic, if you manage your case better and you get the win, you get the win. But if you lie and you get a win, and then they're like, oh, never mind, we took away those points. You've got to do more. I think you've got to do more. There's got to be a counter to that, not just like we're gonna deduct the plus that came to your side. You've got to give the plus to the other side to equal it out. We're coming back. We're coming back. All this sidebar is over whether or not this investigator's photograph should be admitted as evidence. The argument here might be cumulative. We already have pictures of the house, and the pictures we have in evidence already are a better representation of how the house actually was at the time of the event. Yeah, Lisa, I agree. I do not believe Mr. Brennan just today, found out that the criminalists took cuttings of the shirt to analyze them. Can you redact it like this? I said, sure, I can do it. We're cutting off the garage doors.
Okay, Mr. Wolk, whenever you're ready, if you can display that portion. Do you see what has been...
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point, okay?
Oh, I didn't even get to see it. Yeah, no, I have to go see what it was. What was it?
Thank you.
Okay, it was right here. Oh, the door's open here. Can't have the door open. Now she's mad. They blocked out the garage. It's a different picture.
All right, so we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right, so can we get Dr. Laposada in here? We'll do a very brief voir dire of her.
Or we could save time and we could just deny now without the voir dire. There was another sign. I'm going to count that one. We're up to 257 now. When she says very brief, I hear formality. I hear we're gonna go through the formality of doing a voir dire, and then we'll make my denial or make my ruling at that point. We didn't stop counting. I've been counting the whole time. I don't keep it on the screen the entire time. It's like...
Then you're going to step up, face the clerk, and raise your right hand.
Do you solemnly swear the evidence you give the court in case you have the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Good afternoon, Doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those two areas. And if there is support or methodology in Dr. Laposada's resume to point to exactly where that is. Okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth LaPosata. That's spelled Laposata.
Dr. LaPosata, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. LaPosata, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, then we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as an expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
at
medical school?
the medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken.
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes.
Did you, in fact, testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
The judges get an
And what
antsy.
methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
The judges
also
sign
look
a
at the
lot.
other side of that handshake. In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact.
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction consumption?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
What about the CV? Judge is upset that there's stuff that she's going to testify to that's not
Good
listed in
afternoon,
the
Dr.
CV.
LaPosada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites early on?
Yes,
And
I've
you-
had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you
Well,
completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lapasada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on this
in your report
case?
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
In my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
they're taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully. You don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACDAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Commonwealth versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you have been qualified expert for. And that, I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right. Thank you, Dr. LaPosada.
No, you're welcome.
So can I just ask Dr.
Yes.
LaPosada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions?
No.
All right. You are all set. I'm going to ask you to step down, Dr. LaPosada. We'll get to you sometime this afternoon.
Okay. Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Whoa.
Easily. Yes.
If you approve it, then easily, says CJ. Just allow it. Then we don't have to argue. I think based on her answers, I think she should be admitted. There is some concern about her CV not having anything in it about this and the warning to the Commonwealth. I think that's some legitimate points.
Okay.
Brennan's
Eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the two subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these two subjects that's before the bench right now than somebody with Dr. LaPosada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do not think that Dr. LaPosada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training seminar or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. LaPosada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. LaPosada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
I'll briefly respond.
Okay.
She was, Mr. Brennan suggests that, well, she's only been qualified in one court, federal court, but the federal government, the federal judge that was handling that case, qualified her as a dog bite expert in that case. That is not a small thing. That is, as a matter of fact, it's a very big thing for Dr. LaPosada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. La Posada brings much, much, much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. La Posada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right.
I'll submit.
Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All rise for the court, please.
All right, there we go. That's going to take us to our break. Let me, before we go, I wanted to show, somebody was asking if we could go back. Sorry, I already ate my salad. I was hungry, guys. I was hungry, and I couldn't just go without. Wanted to show this on just to see if there was an objection when the shirt issue came up. So we're backing up just a bit.
Sweatshirt other than the right arm.
Well, I know that there was cutting to the.
May I approach and retrieve the exhibit, Your Honor?
Yes.
We're listening for an objection on this one.
Excuse me, sir. Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor.
Yeah, so no objection was made there. She didn't object, but I think it was timely enough the judge allowed it. So she said she's preserved it. All right, where are we? We're going to lunch. I don't know how long we get at lunch. It's 1:41 right now. I'd be surprised if we come back. When did you say 2 o'clock? 2:15? 2:30? I have to go to the end. Somebody could remind me though. Let's see.
Average layperson.
Let's see what you said.
So
2:20. Okay, 2:20. All right, so we're going to be back at 2:20. We've already got a portal set up to move us over there. And we'll just go get some food. I've got to run to the post office. So I'll run to the post office because I've already had my lunch. And when we come back, we're going to have the afternoon session. It's getting spicier and spicier as the day goes on. It's getting crazy. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again at 2:15. Let's do 2:15. That'll be good. Let me set the time here. Edit. I thought we were so late for lunch today. It's so crazy. Find where it is. There it is, 2:15. All right, updated, saved, portal is built. We're all set. Selena K was first in chat in the afternoon session, so she's going to be our internet owner for the rest of the day. But portal's in place. Yes, we're all good. All right. Have a good lunch. It's getting better and better. This is getting spicy. We have top level attorneys doing top level work in the case for all the marbles, and it's getting good. We're nearing the end of this case. I think we could probably count on one or maybe two hands the number of witnesses that are left. It's gonna be really good. All right, we'll see you guys after lunch. Bye bye. Oh, by the way, thanks for liking the stream. We just hit 1,000. Thank you. Appreciate that. We'll see you after lunch. Bye bye.